welcome to The Firm. On the show this week, how to fight sexual harassment, a simple guide for employees and employers. Jet Etihad clear CCI, but a minority decision creates some turbulence. In 1997, the Supreme Court of India acknowledged the hazards to which a working woman may be exposed and the depravity to which sexual harassment can degenerate, and the urgency for safeguards. In the absence of a law, it prescribed guidelines popularly known as the Vishakha Guidelines, but hardly any employer in this country follows them. Why, even the Supreme Court has taken 16 years to constitute an internal complaints committee, a mechanism that the court made mandatory for all employers way back in 1997. Now, if the country's highest court can't follow its own guidelines, imagine how compliant the rest of India has been. The Tehelka incident has underscored how important it is for employers to have effective prevention and redressal mechanisms to deal with sexual harassment, and that employees need to be better informed of their rights in order to take action against such harassment. So today on The Firm, how employers and employees can fight sexual harassment. Any sexually unwelcome behavior, a touch, an advance, a sexually colored comment, showing pornography, asking for sexual favors, an implied threat of detrimental treatment. All of this amounts to sexual harassment, whether the woman is a regular employee or on contract, or a volunteer, a probationer, trainee or apprentice. Even those employed via external contractors are protected by law.
There is no distinction drawn between rape, sexual harassment and molestation under the Sexual Harassment Act. But if you look at it, all of them would come within the ambit of harassment at the end of the day.
In the absence of a law, the Supreme Court laid down guidelines on prevention, resolution and prosecution of sexual harassment in workplaces. That was in 1997. It's taken India 16 years to pass a law on the same lines. But with the rules pending, the law is yet to be implemented.
The application of the law has been widened. It also includes unorganized sector, domestic workers, etc.
I think what's really changed is the way the companies will have to start looking at this, because now there's a lot more penal provisions that sort of relate to non-compliance. So historically with Vishakha, it was largely contempt of court if you didn't comply with it. But going forward now with the new act, there's sort of very visible sort of non-compliance issues that companies need to be worried about.
An aggrieved woman can make a complaint of sexual harassment in writing within 3 months of the incident. The complaint should be made to the employer's internal complaints committee.
Try and gather the evidence before you try and actually go in and raise the complaint. So speak to your colleagues, see if there are other people who face this. The moment you've got at least a couple of people who potentially would have sort of faced this, you've just got that much more ability to go and convince management. I think the other sort of things that you should try and do is, if you have the ability to try and perhaps record things that may be happening. I've sort of dealt with situations where people have actually used their phones and things like that to record conversations. Very quickly try and bring this to the attention of people. Don't let this sort of pass for a significant period of time. I think most people are concerned about even reporting the actual sort of issue, and they sort of tend to wait for a really long time, by which time the ability for the company to sort of gather the right sort of evidence for it starts sort of going away.
By law, at least half the members of the Internal Complaints Committee must be women. Its president a senior woman employee, 2 members from amongst employees who are committed to the cause of women or with social work or legal experience, and 1 external member either from an NGO working on women's rights or someone familiar with sexual harassment issues.
It is encouraged to have people who have either a background in social work or who've dealt with women's issues or have a legal background to be on the committee, because it kind of helps them understand the situation and deal with it better.
External member is important so that to ensure that there is a fair hearing. 2 is that there is no any kind of extraneous pressure put on the woman.
The Vishakha guidelines don't detail an inquiry procedure, But the new law does. If the complainant desires, the internal committee can take steps to conciliate or settle the matter, but no monetary settlement is allowed in a conciliation. Otherwise, the committee, armed with powers of a civil court, has to initiate an inquiry in which it can examine witnesses or other employees under oath and ask for documents or other evidence. Both the complainant and the accused must get a hearing.
The person is met by the committee, which is about 2-3 people along with the external counsel. Her side of the story is heard. Then the committee deliberates. The person against whom the complaint has been filed also is met with separately and heard. The external expert guides as to what should be the resolution.
While the law is silent on who bears the burden of proof, most lawyers say the complainant would need to substantiate her complaint, but failure to do so may not go against her.
The committee must always remember that it is very, very difficult for women to establish, and my personal thing is that the presumption in these issues should be in favor of the woman.
We have to go by the words of the victim, evaluate it against the experiences that we have had. If need be, the committee talks and interviews people with whom both of them have been working with, and we take judicious decision.
Look, there's no denying this is a lonely battle. Rarely are instances of sexual harassment accompanied by hard evidence or witnesses. In such cases, there's always the fear that the accused may argue defamation. Hopefully, the employer will support the complainant in the search for truth. That's what the law requires. The other fear is that of unwanted publicity and even retaliation. All the way back in 1997, the Supreme Court stressed on confidentiality, and the new law does the same. The identity of the complainant and the victim must be kept confidential. The law also prohibits the publication of any details of the complaint, inquiry, and the outcome. As for retaliation, well, the Vishakha guidelines very clearly direct that victims and witnesses should not be victimized or discriminated against. The Vishakha guidelines mandate time-bound treatment of complaints. The new law is more specific. The Internal Complaints Committee has 90 days to complete its inquiry. If the allegation is proved, the committee can recommend disciplinary action to be taken against such misconduct and can also direct the perpetrator to pay compensation to the victim.
The committee itself submits a report to the management, and it's then up to the management to really take a call on what it wants to do. More often than not, when the harassment itself is of a reasonably significant nature, most companies will actually consider termination.
We follow a zero tolerance policy. The person is asked to leave, terminated, period.
The employer has 60 days to act upon the recommendations of the Internal Complaints Committee. But can it choose to ignore the committee's recommendations, take no action at all, or opt for a different punishment?
I think that the employer is required to comply with what the recommendations of the committee are. It would then be a violation in that sense of the statute, and the statute provides for penalty against the employer. There's a monetary penalty at the moment, but if the issue arises again and there's a second violation of the statute, then it actually goes to the extent of saying that the government would have the right to cancel their license or their registration.
The Vishakha guidelines require employers to file a police complaint in the case of a criminal offence, which all this time referred to outraging the modesty of a woman, molestation and rape. But two big changes have taken place since then. Earlier this year, sexual harassment was listed as a criminal offence under the Indian Penal Code. So is the employer required to report sexual harassment complaints to the police? The new law is vaguely worded, but seems to leave that decision up to the woman.
Under Vishakha, what the judgment says is that an employer shall, where an offence has been made out under any other law, initiate proceedings, while under the Act recognizes the agency of the woman and says that if the woman so desires, then the employer shall assist and support her to initiate proceedings.
The companies do not require to go to the police, as far as I know, and all our sources are telling us. So far, there is no law which requires us to go to the police.
Not only is the employer required to follow due process in dealing with complaints, but it is also required to, on an ongoing basis, publicize internal policies on sexual harassment, share committee details, train and sensitize employees, facilitate the working of the committee, cooperate with the inquiry, and assist the woman if she decides to file a police complaint.
One challenge is how to make the female employee feel encouraged and confident to raise the complaint when such a situation, or she finds herself in such a situation. This we do through creating an open culture. We have a structure and mechanism in place. The policy is published. It is available to all employees to see. Through our HR structure, we have ensured that this topic is covered in all the open houses and town halls that we keep having regularly and periodically. Second thing is that when it happens, then our branch and regional committees get into action. The complainant is informed that you can resort to informal and formal process of redressal. Immediate relief is also provided.
If an employer fails to comply with the new law, it could be fined a minimum 50,000 rupees, and repeated failure could lead to cancellation of license or registration. The law attempts to favor the woman. In fact, that's why it's not gender neutral, but only protects women. And yet, what the law intends and what happens in reality are two very different things. So we asked our experts about some of the common mistakes made by both employers and employees.
In my experience, I would say, one, if the companies try to cover up and hide the incident, that's one mistake that they can make. Second is not making employees aware and confident that they can speak up and leadership will give them a proper hearing. I think this is a little elaborate cultural issue which organizations have to deal with and should deal with. What type of ecosystem that they create, what type of responses they give to such complaints, formally, informally, on the ground, because people work with managers and people in far remote places, and only a culture can address this issue.
Similar with employees, one is that they don't file the complaint as soon as they could. Two is that they don't give specific details. And three is somewhere I think we as women need to relook at the way we look at sexual harassment itself in our lives, that it's not my fault.
I'd like to end this story by reiterating the various punishments for sexual harassment. The employer can reprimand or transfer the perpetrator. It could lead to the loss of pay, and it could also lead to termination of employment. If prosecuted criminally, the perpetrator faces 1 to 3 years in prison and or a penalty. The jail time for offences like rape is even more. Alright, that's where we end this feature and take a quick break on the film. But coming up next, Jet Etihad clears CCI, but a minority decision creates some turbulence.